Hey, welcome back. The Supreme Court of the United States is expected to hear arguments in the case of Moore v. Harper in October of 2022. At the heart of this case is the shaky legal theory of independent state legislatures. To help me introduce this theory, I brought on a guest. He is a former failed casino owner, a winner of $3.76 from the NFL by way of lawsuit, and perhaps most notably, former President of the United States, Donald J. Trump.
You are fake news.
Well, hold on, Mr. Trump. We haven't even started the interview.
I don't give a damn.
Anyways, we're going to be talking about judges, and
I want you to be a judge at my next Miss Universe pageant.
no, definitely not.
I'm sorry. I've been very nice to you, although I could probably maybe not be based on the way you have treated me, but I wouldn't do that.
Okay, well, as I was saying, we're going to be talking about Supreme Court justice.
I promise to nominate judges and justices who would stand up for the original meaning of the Constitution and who would honestly and faithfully interpret the law as written.
Okay, that's actually the first good segue because the judges you appointed are trying to use textualism and originalism in interpreting the elections and electors clauses in Article 1 and Article 2 of the United States Constitution.
Then I have in Article 2 where I have the right to do whatever I want as president, but I don't even talk about that.
I don't think you've read Article 2, and I'm not really sure what you mean, but regardless, we're going to cut this interview short.
This has been the most amazing experience of my life.
Wow, you really mean that?
No, I didn't say that at all. I don't think you understood what was said.
Well, you did say that, but whatever.
Go home to mom. Go home to mom.
Supreme Court rulings can seem like a boring topic on the surface, so I just added a little comedy to start off the video. Hope you like it. But the other point in doing that, I also wanted to drive home the point of just how absurd it is that a clown like Donald Trump has had so much influence on the Supreme Court. You know, granted, he just did what McConnell and the Federalist Society asked for, but regardless. The recent Dobbs decision, which overturned Roe v. Wade, reminded the U.S. public how much influence the Supreme Court has over daily lives in the U.S. And by U.S. public there, I mean kind of the apolitical amongst us in the U.S. public. Briefly, I want to outline the structure of the video. First, to understand independent state legislature theory, we need to understand the election and electors clauses in Article 1 and Article 2. And just as a programming note, sometimes I'll say ISL, and that just refers to independent state legislature theory because that's kind of a mouthful. But anyways, next we'll examine how it is that ISL interprets those clauses in Article 1 and Article 2. Third, we will look at the precedents involving ISL-related issues. Next, after seeing the precedents and history that refutes the ISL, we need to answer the question, why is it being viewed as legitimate by conservatives now? Fifth, once we've got the relevant background information, we will look at Moore versus Harper, the case itself. And lastly, to sum everything up, we will talk about the potential political implications moving forward if ISL were to be embraced by SCOTUS, which, another programming note, SCOTUS will refer to Supreme Court of the United States, which, again, just kind of saves time. Anyways, let's get started. When the Constitution was originally drafted, there were two schools of thought among the framers. Primarily, those were the Federalists and the Jeffersonians. Alexander Hamilton and John Adams were the face of the Federalists, and of course, Thomas Jefferson was the face of the Jeffersonians. Their disagreements centered around where government authority should derive from. Jeffersonians, who could categorically be stereotyped as agrarian-minded, distrusted the powerful backers of the Federalists. Jeffersonians believed that federal authority, backed by bankers and the like, would stifle the political representation of rural localities. Meanwhile, Federalists believed that a disjointed government, where state power was supreme, would not be stable enough to provide security and stability for the nation as a whole. That's a brief summary, and it glances over some nuance, but I mention it to properly frame the intention of Article 1 and Article 2 in relation to the election and electoral clauses. The intention was largely a compromise between the two groups, those being the Federalists and the Jeffersonians. State legislatures were meant to have autonomy to preside over both state and federal elections within their own state, as long as they acted in good faith. The second part of Article 1 in the election clause, giving Congress authority to intervene, was meant to safeguard against political sabotage by local governments. So the mechanics of Article 1 are this. State legislatures are in charge of passing procedural regulations over elections for federal candidates within their own state. The electoral clause found in Article 2 deals with the selection of electors for the Electoral College in respect to presidential elections. This again was a compromise by the framers. The North and the South had roughly equal populations at the time of the framing. However, the slaves in the South were not allowed to vote. Therefore, the South adamantly opposed a popular voting system, and the Electoral College and the despicable 3/5 compromise were passed. The compromise was despicable, especially in today's moral understanding of things, because it concentrated political power into the hands of slave owners.
At the Constitutional Convention, there was heated debate on how to select the executive. Some wanted Congress to appoint the president. Others wanted the state legislatures to do it. Still others wanted the president to be directly elected through a popular vote. James Wilson of Pennsylvania was the first to propose the system we now call the Electoral College. Each state would appoint a number of presidential electors equal to their representation in Congress. The winner would become president, provided he had a majority of electoral votes. The runner-up would become vice president. If no candidate won a majority in the Electoral College, the House of Representatives would choose the president from among the top 5 contenders. This design of the Electoral College worked smoothly through 3 presidential elections.
Important to note here, in the context of independent state legislature theory, is the presence of the word legislature in both clauses, and the fact that the federal government, by way of the U.S. Constitution, vests authority over federal elections to state legislatures within the confines of their own respective states. So what then is the independent state legislature theory? ISL is a specific interpretation of the Elections Clause in Article 1 and the Electors Clause in Article 2 that we just went over. Specifically, the interpretation centers on the use and definition of the word legislature. According to the theory, legislature is just the physical body of elected representatives in a respective state that when presiding over federal elections in their state, that body is untethered to its state constitutions. Now, if they're passing any other kind of law, according to Article 6 of the Constitution, which we'll show later, there are many checks and balances on the authority of the state legislature. Now, full disclosure, some proponents of ISL will argue that there is a question of scope in the application of ISL, and that ISL should still honor state constitutions, but only for what those constitutions specifically empower different state bodies to do. Now, this creates a whole can of worms in terms of defining what is specific and what isn't specific enough. So we will ignore this concept for now and just generally focus on the maximalist scope of ISL, which is ISL taken to its logical conclusion, which again is that state constitutions cannot in any way restrict the authority of state legislatures to regulate federal elections within that given state. As mentioned, let's look at the pyramid of authority of law in the United States as outlined in Article 6 of the U.S. Constitution. So with any new law or statute that a state legislature could pass, it is normally beholden to multiple different checks. A state constitution usually has many of these checks found within itself. First, the state courts are usually charged with interpreting that state's constitution in regard to any new laws and statutes. Second, many state constitutions have provisions which allow for the governor to veto proposed law or statutes. Finally, direct democracy initiatives like referendums are also sometimes found in state constitutions. All three of these elements can, in effect, nullify any law proposed or passed by state legislatures. ISL holds that the power to carry out federal election derives from the U.S. Constitution to the state legislature. Therefore, it supersedes the state constitutions and the interpretations thereof by state courts. So somehow, in regulating federal elections in their state representatives would not be tethered to the bounds of their state constitutions like they would in any other aspect of their legislating, which is ridiculous. This is like understanding that there should also be a independent Congress theory where when Congress is passing laws, it is not subject to checks from the veto power of the president or the judicial review from the Supreme Court. The only check to the state representatives' power under ISL would then be federal courts and ultimately SCOTUS. As I speculated earlier, the purpose of the election and electors clauses in Article 1 and 2, respectively, was a compromise to protect state governments against the influence of federalism. ISL aims to undo that compromise. I'd like to disclose that much of the research in the rest of the video comes from the Amar Brothers article, Eradicating Bush League Arguments. It's an excellent article even for a layman such as myself, and I'll put a link to the article in the description. Anyways, let's now look at the history from the founding of the U.S. that undermines the independent state legislature theory. State constitutions, since the era of George Washington's first presidential term, have regulated federal elections in their states. For instance, the Delaware 1792 state constitution required election of congressional representatives to occur at the same place and in the same manner as state representatives. The coupling of state and federal election rules is something we will talk about later, but for now, just think how difficult it would be to say that on one hand, state courts can weigh in on laws pertaining to the election of state representatives, but not for federal ones. You'd have to have two separate elections or one just very confusing one, if it were even possible to have one. Anyways, the state constitutions of Georgia in 1789, Pennsylvania in 1790, Kentucky in 1792, all required elections to be done by ballot and not voice. Overall, more than half of the 11 states that ratified the U.S. Constitution in 1787 through 1788 had state constitutions that explicitly regulated the legislature in their state in the context of federal elections.
But almost every version of the ISLT starts with the claim that the elections and electors clauses, which give state legislatures the authority to regulate federal elections, mean that when legislatures do so, what their own state constitutions require or prohibit does not matter. Nothing in the clauses compels that reading. An at least equally natural reading recognizes that legislatures are creatures of their constitutions and so may make laws only as allowed by them. Historical understanding and practice overwhelmingly support this latter view. A few highlights. From the time of the founding, state constitutions have regulated federal elections. Between 1789 and 1803, at least 6 state constitutions regulated whether elections should be by ballot or by voice vote, which was extremely controversial at the time, and those provisions were understood to apply to federal as well as state elections. Some early state constitutions explicitly regulated federal elections. The Delaware Constitution of 1792, for example, expressly regulated the election of congressional representatives.
Next, we are looking at SCOTUS precedents that have examined the meaning of the word legislature in the context of the elections and electors clauses of Article 1 and 2. All the following undermine the independent state legislature. First, we have Davis v. Hildebrandt in 1916. In that case, Ohio State Constitution included a provision that allowed for referendums by voters to approve or disapprove of any law passed by its state representatives. The Ohio State Legislature passed a redistricting measure, and a referendum by the voters later struck it down. The Ohio State Legislature appealed to SCOTUS, claiming that Article 1 was being violated because it is only state legislatures that are empowered to carry out congressional elections. SCOTUS rejected this claim and upheld the authority of the referendum, and did so by asserting that the legislature is bound by the state constitution. So with this ruling, the Supreme Court has initially ruled that the legislature is not just the representatives. It also includes the voters, because their authority by the state constitution allowed them to pass a referendum, essentially blocking the resolution of the legislature. Next, in 1932, we have Smiley v. Holm. Again, a Minnesota legislature passed a redistricting proposal. The governor at the time in Minnesota vetoed it. The legislature sued, citing Article 2 elections, claiming they didn't need the governor's authority to enact election protocol. SCOTUS ruled with the governor, asserting the following: the exercise of authority to regulate congressional elections must be in accordance with the method with which the state has prescribed for legislative enactments. So now, after 2 cases, the meaning of legislature includes voters and governors. Third, we have Arizona State Legislature versus AIRC in 2015. Ironically, this started in the year 2000, the same year as the Bush-Gore election. A voter initiative, Prop 106, passed, which empowered an independent commission to redistrict in Arizona. Again, SCOTUS ruled in favor of the voters, with Ruth Bader Ginsburg stating the following: nothing in Article 1, nor has this court ever held, that a state's legislature may regulate the manner of holding federal elections in defiance of that state's constitution. Again, the definition of legislature has expanded, this time to include independent commissions as authorized by the voters in accordance to the state constitution. Just briefly, I'll mention Rucho v. Common Cause in 2019. It's similar in circumstance to the other cases we've looked at, but surprisingly in this case, Clarence Thomas penned the majority opinion rejecting ISL. Also, another outcome of the ruling was that federal courts were ruled not to be the medium for addressing gerrymandering within a state, and that avenue is more properly the state courts. So with all this precedence, why is ISL now relevant? First, we must look at Bush v. Gore in 2000. Closely contested presidential elections in the past were settled by Congress, such as 1800, 1824, and in 1876 by a joint effort of Congress and the Supreme Court. So, first of all, it was very strange that the Supreme Court in 2000 intervened on its own in deciding a presidential election.
But in 1800, there came a bump in the road. Republicans had slated Thomas Jefferson for president and Aaron Burr for vice president. At the time, the Constitution required electors to cast 2 votes for president. The winner would become president, and the runner-up would become vice president. But in 1800, there was a deadlock. Jefferson and Burr received exactly the same number of votes. The election was decided in the House of Representatives. Such a deadlock could never happen again. In 1804, the states ratified the 12th Amendment to the Constitution. Electors would now cast separate votes for president and vice president. The 12th Amendment also lowered the number of candidates the House would consider from 5 to 3. This became a factor in 1824, when another election was thrown into the House of Representatives. For the first time, no candidate won a majority of the electoral vote. Andrew Jackson had a big lead in electoral votes. Jackson also led in what was considered the popular vote at that time. The House of Representatives voted among the top 3 candidates and selected John Quincy Adams. The support of Henry Clay, the Speaker of the House, was crucial to Adams's win. Jackson and his supporters were infuriated. They believed that Adams won because he had promised to appoint Clay Secretary of State. Jackson called it a corrupt bargain and made the alleged deal between Adams and Clay a campaign issue in 1828, when Jackson won by a landslide. Another challenge came in 1876. Democrat Samuel Tilden won the popular vote. He was leading in the Electoral College until results from South Carolina, Louisiana, and Florida appeared to give the victory to the Republican, Rutherford B. Hayes. Those 3 former Confederate states were the only ones still occupied by federal troops. Those troops remained to enforce Reconstruction voting laws. Tilden accused the Republican officials of those states of stealing the election for Hayes when conflicting electoral vote counts were submitted. In the face of this unprecedented claim of fraud, the Electoral College result was in doubt. Congress created an independent commission to resolve the disputed vote. This solution was not even hinted at in the Constitution. It was composed of 5 members each from the House, the Senate, and the Supreme Court. The commission determined that Hayes had won. While Democrats in the House threatened to block the decision, Congress finished counting the votes on March 3, 1877. On March 5th, Rutherford B. Hayes was sworn in on schedule. In 2000, Florida was once again at the center of a disputed presidential election. Democrat Al Gore won the popular vote by almost 500,000 votes. With 49 states accounted for, he led the Republican, George W. Bush, in the Electoral College 266 to 246. Florida's 25 electoral votes were enough to give the electoral vote majority to Bush. Bush's margin of victory in Florida was less than 2,000 votes. Gore challenged the outcome, asking for manual recounts in 4 heavily Democratic counties. The Florida Supreme Court, arguing that the need for accuracy must be weighed against the need for finality, ordered a statewide manual recount. The U.S. Supreme Court overruled the Florida court, holding that with no uniform standard to judge voter intention, a statewide manual recount would violate the 14th Amendment's Equal Protection Clause. The court's decision was greeted by a furor of protest from Democrats, but Gore agreed to abide by its decision, and George W. Bush was declared the victor more than a month after Election Day.
Gore petitioned the state courts for an extension to the recount. The Florida Supreme Court granted the extension recount for ballots that did not have a vote counted for the presidential line of the ballot.
I guess my answer to that is I'm absolutely adamantly opposed to that.
SCOTUS, by a partisan line of 5-4, ordered the recount to be stopped. According to Amar's article, that I mentioned earlier. Of the five, O'Connor and Kennedy believed the equality clause of the 14th Amendment, and the other three really believed in ISL, but for the sake of stopping the recount,
Find ways to cut corners.
agreed with O'Connor and Kennedy about the equality clause. So first, to discuss the equality clause objection, we must first mention the fact that there were physical ballots used, and hanging chads or dimpled ballots were a big issue in the recount. It should be noted that there wasn't an established Florida statute at all for dealing with dimpled ballots. The more heavily Democratic districts in this election were more heavily populated, as they usually are. So therefore, there were longer lines, and also it was alleged that the voter machines in those districts were older and less maintained. So those two factors led to a lot more incompletely punctured ballots, or hanging chads or dimpled ballots. So by issuing the recount in these areas, the Florida Supreme Court was trying to reverse the discrimination that had occurred against voters in those areas, which is why it was so problematic for SCOTUS to invoke the equality clause. And their reasoning was that if you only check the dimpled ballots in those districts, then what if there were dimpled ballots in Republican districts that would have led to more votes for Bush?
This is a very important topic, and it's a very sensitive topic because a lot of good people disagree on the issue.
The use of the equality clause in this case was in bad faith when you consider just the existence of the lower quality voting machines in the contested districts, combined with the fact that those districts experienced longer lines. Now to the ISL part of Bush v. Gore. In the case preceding Bush v. Gore, there's a case, Bush v. Florida Canvassing Board. Chief Justice Rehnquist, Thomas, and Scalia maintained that by extending the deadline for the recount, election laws were being changed by the judiciary after the election day. In Bush v. Florida Canvassing Board, the case was closed and it was remanded down back to the Florida Supreme Court to answer the question of whether Article 2 violations were occurring. Later, in the main case that became Bush v. Gore, Chief Justice Rehnquist wrote a concurring opinion that Scalia and Clarence Thomas, who of course is still on the court unfortunately, concurred with. This invoking of the ISL is one that is more narrow in scope, and its rejection of the Florida Supreme Court's decision is basically that there's no specific measure that grants authority for Florida courts to enact a recount on the basis of interpreting voter intent with regard to the hanging chad ballots. So in other words, because the Constitution doesn't explicitly and literally say that Florida courts can do a recount in addressing hanging chad ballots, then the Florida Supreme Court has no authority to do so. So while Florida Supreme Court would argue and did argue that they were doing their best to ensure counting the votes accurately, and that is in fact a duty outlined by their state constitution. Instead, ISL says that there must be a specific statute existing prior to Election Day for them to do that in regard to the specific issue of the hanging chad ballots in context of the recount. Bush v. Gore was a messy case and had a lot of moving parts, so generally, from what I understand, it is not perceived as being a strong precedent. That is, unless, of course, you happen to subscribe to the Federalist Society and their way of thinking. So now we're going to fast forward to the 2020 election, and ISL is again being cited, but this time it's much more broadly than it was in 2000. On October 26, 2020, Kavanaugh chided Wisconsin Supreme Court for intervening so close to an election in the case of DNC v. Wisconsin State Legislature by citing the Rehnquist 2000 remand in Bush v. Florida Canvassing Board that we mentioned. 2 days after that, on October 28th, 3 more justices cited ISL to petition Roberts to undo the rulings of Pennsylvania Supreme Court, where that court had ruled for an extension to the deadline of mail-in ballots. The Pennsylvania Supreme Court, after the United States Postal Service stated that they couldn't confidently guarantee the timely delivery of mail-in ballots, extended the deadline for receipt of mail-in ballots from 8 p.m. Election Day to 3 days thereafter, provided that the ballots were postmarked by Election Day. The argument the Pennsylvania Supreme Court made, in addition to United States Postal Service shortcomings, more on that later, was that a COVID surge on Election Day could dissuade voters who had planned on voting in person. Therefore, by extending the deadline, their suffrage was being protected. And this was, still in the, not necessarily the outset of COVID, but while COVID was definitely a problem, and we still didn't know very much about it. So, in petitioning Roberts to strike the Pennsylvania ruling, and keep in mind this is October 28th, so we're talking about a week before the presidential elections. Alito wrote the opinion asserting that federal election authority derives from the federal government to the states and not the other way around. What's interesting here is that while Kavanaugh cited ISL on the 26th, he chose not to join Alito, Thomas, and Gorsuch in the Pennsylvania Supreme Court opinion. Had he done so, another kind of Bush v. Gore situation could have played out in a time of even higher political turmoil than in 2000. Now, with some background on ISL, let's turn to Moore v. Harper. On November 11th, 2021, the North Carolina General Assembly, or state legislature, adopted a new congressional voting map based on 2020 census data. A group of Democratic voters and nonprofit Democrat organizations sued in the North Carolina State Court, alleging that map infringed on voters by being too gerrymandered. And if we remember back to the Rucho case that we briefly mentioned, the federal court said that was the avenue for it to be settled. Anyways, on February 14th, 2022, the North Carolina Supreme Court ruled that the state could not use the map for 2022 elections and appointed 3 experts to redraw the map. 11 days later, Harper, who is the Speaker of the House for the North Carolina legislature, and the rest of the Republican state legislators filed an emergency appeal to SCOTUS asking for a stay in the North Carolina Supreme Court's decision. This was denied. Alito wrote a dissent, which was backed up by Clarence Thomas and Brett Kavanaugh, in which Alito stated, "The independent state legislature doctrine is an important question for this court to resolve." And as I stated, I'm a layman, but through some of my research, usually a doctrine is reserved for a legal theory that is accepted by the legal community as a whole as being legitimate. And him calling it a doctrine, to me, is a sign that he, Clarence Thomas, and Brett Kavanaugh are planning on using ISL as legitimate moving forward. But we'll see. Just a side note, I want to point out that according to a 2011 North Carolina statute, 1267.1, and I'm just going to paraphrase it here, but any action challenging the validity of any act of the General Assembly that apportions or redistricts state legislative or congressional districts shall be heard by a Wake County senior resident superior judge and 2 others as appointed by the North Carolina Chief Justice. So there's literally a state statute that says that the proper avenue for resolving redistricting conflicts is the courts, specifically the state courts. So in order for a maximum scope ruling of ISL to be used by SCOTUS, it seems to me they would have to be argued that the state legislature itself acted unconstitutionally with respect to Article 1 by giving authority to the courts, because the courts are an agency outside of the legislature themselves. As the Dobbs case showed, this court is brazen and in no way cares for precedent, so I won't be shocked if there is an absurd ruling handed down in this case. Let's now look at some of the implications of ISL if it were to be adopted as legitimate by the Supreme Court. If it were adopted, federal courts are now the authority on interpreting state laws with regards to federal election laws. This is concerning because the Supreme Court justices do not have more expertise on each individual's state laws than the judges in those states. Now, granted, Gorsuch would argue that his superpowers of textualism make him the foremost authority on any law, because by focusing on the text of those laws, he doesn't have to consider precedent, but that's besides the point.
To put the text of the Constitution out there. In terms of your question about sort of the role of textualism, I mean, I think there are a couple of ways in which the claim, this independent state legislature, either theory or, as Carolyn's piece calls it, claim, I think either referring to it as a theory or a claim is far superior to referring to it as a doctrine, right? It's not been accepted. And in fact, it doesn't really have the coherence of a doctrine, I think. So claim or theory is the best way to describe it, to my mind. But it has, textualism, I think, is at the heart of it. So I think the way that Leah and I focus on one aspect in this piece that we have drafted. So we focus on one circumstance in which this claim arises, which is where a state court or a state executive branch entity has interpreted a state statute related to, election administration typically, and sometimes in explicit light of state constitutional voting related provisions, reads a state statute in a particular way. And the claim is that federal judges can override the interpretation by state officials, by themselves, federal judges, reading the state statute in a way they think is proper, reviewing it de novo, and reviewing it in using textualism as the only legitimate and defensible method of statutory interpretation with which to interpret that state statute, and sometimes correcting supposedly insufficiently textualist interpretations offered by state courts or state executive branch actors. And so interposing their really textualist grounded interpretation of the statute on other state interpretations. And so briefly, sorry, let me back up a little bit before you asked broadly, what is textualism? So a method of interpretation that, is longstanding, has had, earlier iterations, arose in its sort of current or, relatively current incarnation, I would say in the 1980s when Justice Scalia was ascended to the Supreme Court, and to a degree when he was on the DC Circuit, that disavows reliance on extra textual sources like statutory or legislative history or purpose or context, and focuses, at least officially, on the text of the statute, and then allows consultation of extrinsic sources like dictionaries and canons of interpretation, either textual or substantive canons. But so that's essentially textualism as a method. And as Leah and I explain in this article, and then I'll stop and pass the mic to Leah, textualism developed as a method, in the context of federal courts interpreting federal statutes, and with very explicit reference to the norms of legislative passage that obtain in the federal system, and in fact have very little to do with the process of the passage of laws in the states at all. So it's a profound category error to suggest that textualism, even if it is the right way to interpret federal statutes, is appropriate or mandated when it comes to the interpretation of state statutes. And that, in fact, is at the heart of the independent state legislature claim, at least in the context in which Leah and I are talking about it, which is somewhat distinct from the context in which state legislatures assert the authority to themselves directly appoint presidential electors, irrespective of whatever vote has been cast in the state. So maybe I'll stop there and let Leah pick up.
By establishing state legislatures as no longer being tethered to their state constitutions, what would stop them, say, from passing a law before Election Day to the effect of saying that any disputes or recounts will not be handled by the judicial state courts, but instead by us, the state representatives? At the very least, the representatives would be in charge of appointing arbiters, and those arbiters would have no guarantee of neutrality. In cases like Bush v. Gore, where there isn't time to fully consider precedent, things get messy. If ISL is allowed to be taken seriously, the Supreme Court becomes the authority on interpreting state laws in respect to federal elections. It can then essentially rule as a partisan kangaroo court. They choose which cases to hear and can decide to hear cases that favor conservatives to exert their influence after the fact, thereby exerting their influence over the outcome of federal elections after the fact. ISL also presents a unique problem that arises from the need of decoupling the legislature's power over state elections versus federal elections. It is common for election laws passed in states to equally affect state and federal elections in those states, which is to say ISL would have to decouple that process. As it stands now, if a state legislature passes an election law before the election that is then struck down by veto, courts, referendum, etc., let's say then, after it's struck down, it's not challenged before the election in the Supreme Court. The election then happens. What then would stop a losing federal candidate from asserting that the election was compromised because the original election law that presumably favored their case was unconstitutionally struck down by a state authority who in fact did not have the authority to do so in respect to the federal election? A lot of gray area is created. Requiring that the mail-in deadline in Pennsylvania not be extended due to existing statutes could be perceived as a rational argument if it's considered in a vacuum. However, when you consider the context, it is much more sinister. There's a deep dive to be done here, but just briefly, Trump appointed Louis DeJoy to head the USPS. And as Trump would say, I know the best people, believe me, believe me. DeJoy is a man that between his wife and himself has up to or upwards of $75 million invested into companies that directly compete with the United States Postal Service. It's fair to say then that DeJoy's goal was never to improve the United States Postal Service. In the context of mail-in ballots being more necessary during COVID, DeJoy's purposeful slowdown of the USPS clearly constitutes voter suppression, in my opinion. If it could be proved that Trump made the political calculation that the less votes, the better off he would be, it constitutes a scheme, in my opinion. This is to say that auxiliary meddling could make federal election laws seem innocent on their face, but when combined with sinister meddling and put into the right context, those innocent election laws could easily be part of a conspiracy, so to say. And again, to define conspiracy, it's not some wackadoo idea. A conspiracy literally means collusion among multiple parties to commit some sort of illegal act, such as voter suppression.
Committee. Thank you for the opportunity to testify about this dangerous and unprecedented legal claim being pressed by conservative activists. As you know, the Supreme Court agreed to hear Moore versus Harper, a case in which some North Carolina legislators have asked the court to embrace the so-called independent state legislature notion. This is the radical claim, theory is too generous a word, positing that the Constitution removes the normal checks on state legislatures when they regulate federal elections. You've already heard that the claim is wrong. The constitutional text, American history, Supreme Court precedent, sound policy, and common sense all refute the notion. I'll focus on the crushing consequences for American voters and our multiracial democracy if the Supreme Court turns this fringe notion into law. Here are 4 examples of what this idea could allow. First, the notion would greenlight partisan gerrymandering for congressional elections. A state legislature could draw an extreme partisan gerrymander without consequence, something that the state court would otherwise strike down as illegal under the state constitution. That is just as backwards as it sounds. State lawmakers could violate their own constitutions. Redistricting commissions in up to 9 states would become defunct, and fair representation could become even more difficult, if impossible. That's because the Supreme Court already took federal constitutional protections off the table, ruling in the Rucho case that federal courts cannot stop partisan gerrymandering. The court pointed to state courts as the answer, but if state courts can't stop partisan gerrymanders, the tactic will thrive. Second, the radical claim will remove constraints on voter suppression. For example, a legislature could eliminate early voting, even if it's articulated in the state constitution and adopted by the people through direct democracy. The governor would be unable to stop this decision, and a state court would be powerless to stop it as well. Yes, voters could bring their case to federal court, but the Supreme Court has gutted the most powerful provisions of the Voting Rights Act and undercut other federal voter protections. Third, the notion would create election chaos, disenfranchising voters and overwhelming election officials. The claim would undo hundreds of election laws in state constitutions enacted by ballot initiative and implemented through administrative rules. Policies enacted through direct democracy, like mail voting, same-day registration, and even voter ID, could be wiped off the books for federal elections. Voters could be blocked from voting for candidates for federal office, even if they are eligible and they properly registered to vote. A range of other policies established in state constitutions rather than legislation would be voided. The right to cast a secret ballot, for example, is established in 44 state constitutions. Election officials would be forced to administer a 2-tiered complex system with different policies for state and federal elections. It would be unclear which rules actually apply. And if election officials don't know what the law is, voters surely won't. Fourth, the notion would remove critical checks against election interference and sabotage. The radical idea could enable legislatures to manipulate election outcomes. For example, they could enact arbitrary rules for counting votes. The claim would invite legal challenges asking federal courts to throw out ballots cast in reliance on constitutional provisions, laws enacted by ballot initiative, or policies implemented by election officials. To be clear, the independent state legislature claim is not a license to coup. Federal law prohibits state legislatures from overturning the results of elections. But the notion would open the door to anti-democratic shenanigans, and even failed efforts to manipulate our elections erode trust and ultimately participation in our democracy. Even if the court embraces this radical notion, Congress can thwart many of its worst consequences. The Elections Clause, the very same constitutional provision that activists are trying to weaponize against democracy, gives Congress the power to enhance and protect voting rights and ensure fair representation. Regardless of how the court rules, I urge you to revisit and pass the Freedom to Vote John R. Lewis Act. The bill would set national standards for voting access, prohibit partisan gerrymandering, add federal protections against election interference and sabotage. This legislation is critically needed. Thank you.
Those concerns in mind, it'll be interesting to see the outcome of Moore v. Harper. Will Kavanaugh reassert his initial embrace of ISL, as he seemingly did with taking up the case to begin with? Another interesting question is, how will Amy Coney Barrett rule? She hadn't been sworn in when SCOTUS was considering ISL in context of the 2020 elections. And I think if someone were to make the case to Amy Coney Barrett that it would move us one step closer to the Handmaid's Tale, she would very openly and warmly embrace ISL, but we'll see about that, I guess. My closing opinion is that federal courts should only intervene if they detect inconsistency in the state's application of laws based on precedent of those state courts in interpreting the same laws and statutes. Also, a state constitution is, in effect, a contract between the citizens and the state government. Therefore, state legislatures derive their power from the state constitution and not the other way around. If the state government isn't bound by this contract between the citizens and the government, where are they getting their authority from? Because the whole point of this is, the whole point of a democratic republic is to elect officials to represent you. And so if the power isn't derived from the contract that exists between the people who want to be represented and those people that they elect to represent them, then what's the point of all this anyways? Hope you liked the video. Thanks for sticking around to watch it. Like and subscribe if you did like it, and I'll see you in the next one. And feel free to leave any comments. Thank you.